I'm going to introduce now our next speaker, Sheriff Susan Craig, whom I know very well. Susan is the interim director of Judicial Institute for Scotland, and for those who aren't familiar with that title, that's basically judicial training. And I hope you're all encouraged to know that judges do get regular judicial training, and there's an opportunity here to feed into that because it can be quite influential. Susan became a sheriff in 2011 as a part-time sheriff and was appointed as a full-time sheriff in 2013, working in the Lothian Borders, mainly Livingston, I think, Susan. In 2017, she was appointed by the Lord President as Deputy Director of the Judicial Institute. And prior to becoming a sheriff, she was a practicing solicitor involved in litigation. In 2003, she was appointed as an employment judge, and so has been involved in that judicial side of life since then. But I think it's worth recognizing that on her journey through the profession, there have been a few glass ceilings broken. And back in 1994, Susan was admitted as only the second female solicitor advocate with extended rights of audience in the superior courts, and was accredited by the Law Society of Scotland as an employment law specialist. So it gives you a flavour of the journey she's come on in her background when she comes to speak to us today. She's a member of the Advisory Council to the Judicial Institute from 2014 and remains so in her formal office as Deputy Director. And from 2014 to 2021, she was the Sheriff Non-Executive External Member on the Scottish Courts Tribunal Service People Committee. A great title, but an extraordinarily important part of the Scottish Courts Tribunal Service. From 2013 to 17, she was the Lothian and Borders elected representative on the Council of the Sheriffs Association and is on the Board of Governors of the Dean and Coven Young People's Trust. But not content with being a solicitor, Susan was also admitted to the Faculty of Advocates back in 2015. She's going to speak to us this afternoon about when children and courts converge, judicial training on children and young people. Over to you, Susan.
Well, thank you, David, and it's lovely to see you. It's been too long since I've seen you. It's lovely to be here, and thank you for that warm welcome as well. As David says, I'm going to speak to you about when children come into contact with the courts and what training we provide for sheriffs and judges to arm them with the tools that they need. But first of all, just some formal introductions from myself. My name is Susan Craig and I'm a sheriff. I'm currently the Deputy Director of the Judicial Institute for Scotland. Don't worry too much about the titles. There's been a bit of flux in the system over the last year or so, but I was interim director and now I'm deputy director, and the reason for that is because I'm planning to step back from the JI in September and go back to judging on a full-time basis. When I'm working in the JI, I spend half my time sitting in court as a judge, and the other half of that time is spent designing and delivering training for judges. And as I say, in the last 9 months, I've been doing that on a full-time basis. As I'm sure you know, and David definitely knows, the jurisdiction of a sheriff is very wide indeed. Personally, I hear a huge number of different types of cases, both criminal and civil, involving both public and private law issues. I hear cases about children, such as adoption, petitions, permanence applications, care proceedings, cases about contact and residence, as well as cases involving guardianship in relation to adults. And for these purposes, and why it's relevant to us today, is that's anyone who's age 16 or over, who lacks the capacity to look after themselves. I also hear cases involving high-end commercial contract disputes, sequestration proceedings, local authority housing recovery cases, and in the sheriff court, all human life is there. But with such a wide jurisdiction, it could be a challenge to keep knowledge, legal knowledge, up to date, and at the same time make sure that you understand and are aware of what's happening in the wider society. But judges do have a duty to make sure that they keep up their skills up to date and keep their knowledge fresh in order to carry out their duties. The Lord President, who, as you will know, is Scotland's most senior judge, Lord Carloway, has statutory responsibility for ensuring that all judges sitting in the Scottish courts and in the devolved tribunals as well are adequately trained and educated. That responsibility, that statutory responsibility, is delegated to the Judicial Institute for Scotland, which was set up specifically to deliver on that responsibility. Now, the JI, we call it the JI, but I'll slip between Judicial Institute and the JI. But our core principle is that judicial education is judge-led, judge-devised, and judge-delivered. And that is there to reflect that the independence of the judiciary, both from the state, independence from the state, and indeed independence between one another, is a central pillar in a democratic society. And indeed, it is the first value in the Bangalore Principles for Judicial Conduct, which is a United Nations document intended to establish standards for ethical conduct of judges. And these principles, the Bangalore Principles, are designed to provide guidance to judges and to offer the judiciary a framework for regulating judicial conduct. There are 6 core values as independence, which I've already mentioned, impartiality, integrity, propriety, equality, and finally, competence and diligence. We teach the newly appointed judges about the Bangalore Principles, and in our ongoing work through their careers aim to promote and support the core values too, particularly that of competence and diligence. Now, I did mention that our philosophy is that judicial training must be judge-led. So the organisational structure of the Judicial Institute puts serving judges in its leadership roles. The director and deputy director are both serving sheriffs, and the chair and the vice chair are both High Court judges, senators. Together, the 4 of us make up the board, and we meet 4 times a year to take strategic and business decisions. We're supported by a group of civil servants, and there's currently, I think, 14 members of staff, and they are employed by the Scottish Courts and Tribunal Service, but they work for us at the JI. Now, David, as you know, as a serving sheriff, was a great supporter of the JI. And Maria Galli, who's also with us today, and you'll hear from her later this afternoon, she's a regular contributor to our courses, and we're very grateful to her for that. But for the rest of you, you are unlikely to be aware of the work of the JI unless you are a criminal practitioner appearing in jury trials, and so a user of one of our most prestigious publications, that's the Jury Manual. But even if you do use the Jury Manual, you might not be aware of the breadth and the depth of the work that we do. And that's because our customers, in sort of air quotes, are not the public, it's not the professions, but instead it's the judiciary of Scotland. And that is all court and tribunal judges from the devolved tribunals. So that means all High Court judges, justices of the peace, sheriffs principal, sheriffs and summary sheriffs. Now that alone is several hundreds of people, I should say. And if you add in the judges from the devolved tribunals, that probably doubles the number of judges that we train. So what is it that we do? We have a core curriculum of courses which we deliver through the course of the year. Now this year in 2022, we are delivering over 30 separate courses. Some of these are single day courses and a number are multi-day ones lasting for a whole week. Now those multi-day ones are the induction courses for newly appointed judges, and those are the courses that are, or the only courses I should say, that are mandatory for judges to attend. This year we'll deliver that mandatory training to around 50 new judges, mostly sheriffs, but also to the 5 new senators who were appointed last month. We had a week-long induction training course with them in May. For sheriffs and summary sheriffs, they can attend up to 4 separate courses in a year, and they get to choose which ones they would like to attend from our curriculum. It is not a form of CPD, and there's no pass or fail, and we don't report back to their sheriff's principal about their performance on the course. Instead, we describe our courses as being a safe learning space, which are peer-led, meaning that the majority of modules have speakers who are professional judges, or we have external speakers who are subject matter experts. Training for senators is bespoke and is designed to respond to specific issues as they arise in the High Court or the Court of Session from time to time. And just to give you an example, tomorrow I will be delivering the second of a series of courses on trauma, which looks at the experience of witnesses giving evidence in cases involving serious sexual abuse and rape. We teach about vulnerabilities in court, the correct use of the statutory rape shield, human trafficking, taking evidence on commission, the management of high court trials, to give you just a very few examples of the training that we deliver for senators. Justices of the peace have training locally within their sheriffdoms, but must attend at least one Judicial Institute course every 3 years. And we deliver courses on courtroom communication, road traffic, decision-making, and dealing with the unrepresented accused. And there are 8 of those courses available to JPs every year. In addition to that, we have a bespoke courtcraft course for the tribunal judges, and that runs twice a year. Now, every single one of these courses is designed from scratch by the judicial leads, that's myself and the other director. So that is from the initial identifying of subjects on which we want to train, identifying emerging themes, being aware of upcoming legislation, through to selecting speakers, whether they're internal or external, writing and directing the content, and then delivering the courses themselves. We don't buy in courses, we design everything. You might also be interested to know that issues of equality, diversity, the social context and awareness of the social context are taught pervasively through every single course we deliver. I would like to say a little bit more about the induction course that I've mentioned, because that is the only form of mandatory training in the sense of being statutorily mandated for judges to attend. You probably know that new judges are selected by an independent body. That's the Judicial Appointments Board for Scotland. So by the time they get to us for induction training, they've already been in effect pre-screened as suitable for the role that they're going to carry out. But as you might imagine, the new judges will come from a very wide range of professional backgrounds. Some may have been career prosecutors and have never, or at least not recently, seen the inside of a civil court. Others will have had very successful careers as, for example, family practitioners. But they all have to be trained so that they can take on all of the very wide variety of duties of a sheriff. The induction programme starts with a module on finding your judicial voice, then moves through training on ethics, diversity, and the social context. We look at forum management, prevarication and contempt of court, judicial welfare, and the unrepresented parties. And that's just day 1 of 5. Over the rest of the week, we have workshops on sentencing, and that includes a presentation from a prison governor who presents a warts and all portrait of prison life, designed to highlight how damaging a period of custody can be, and that it really must be the last resort, as well as having discussions around domestic abuse and coercive control, jury management, jury charging, and sentencing in solemn cases. In addition, there are specific modules on children and young people, and they are delivered by specialist judges. And all of this is designed to equip new judges with the skills they need to take on their new role. Now, induction is a very intensive week, both for the directors who design the course and deliver it, and also for the new judges who attend. And I tend to find that it's a bit of a revelation to the new judges to discover just how wide and complex their workload is going to be. But hopefully we help give them the skills that they need for that. Now that sounds like we do a lot of courses, and we do, and it's certainly a key part of what the Judicial Institute does, but it's only part of our delivery of training and education. We also produce a large volume of resources on the law, policy, procedure, and social issues of relevance to judges. And all of these resources are hosted on our learning management platform, which is called the Judicial Hub, and that is accessible to judges only, but every judge has the ability to access that on any form of equipment and at any time. So I hope that's given you a bit of a picture of what it is that we do at the JI, although it is, to be fair, a bit of a whistle-stop tour. If you do want to know more, if I've whetted your appetite for that, you'll find that there's a number of public-facing publications that would be available to you on the Judiciary of Scotland website, and that includes our annual report, which sets out the courses and what the work that we do on an annual basis, and also our 3-year strategy. And I'd encourage you to have a look at it. There's a lot of useful information there, and we want the wider public to know what it is that we do. What I'm going to do now is go a bit closer to the brief that I was given, which is to look in a bit more detail at the training we provide to arm judges with the skills they need when they're dealing with cases involving children and young people. And it struck me that the first question we'd have to ask ourselves is, when do children come into contact with the courts? And while it's a little simplistic, broadly speaking, children come into contact with the court system in 3 circumstances. They can be witnesses in criminal trials. They can come into court as a result of care decisions taken by the hearing system, or in civil proceedings that seek to regulate contact or residence with the adults in their lives. Now, very often these 3 are not mutually exclusive, and it's entirely possible that a child might well find themselves involved in each of these 3 circumstances. For example, a child giving evidence about the behaviour of a relative may also have been referred to the children's hearing system because of that behaviour, and also be the subject of a contact application by that same relative. So you'll see that there is considerable overlap, or at least the possibility for considerable overlap, between a child's contact with the court. There is, of course, one further category where a child can become involved with the court system, and that is where it is the behaviour of the child that is in issue. As I'm sure you all know, the age of criminal responsibility is now 12, which means that no child under the age of 12 can be guilty of a crime. Now, I don't propose to comment on whether or not that is the appropriate age, because that, of course, is a matter of policy. But it does mean that behaviour of a child under the age of 12, which would amount to a crime if committed by an older child, cannot be prosecuted. Instead, that child will be treated as a witness, and if referred by the reporter to a hearing, it will be on a non-offence ground. So children aged 12 and over have the legal capacity to commit crime. Crown Office has a number of prosecution policies that regulate whether a child criminal, and again air quotes on that, a child criminal, will be brought into the court system or instead dealt with through the hearing system. And it's fair to say that these policies vary over time. But whichever route is taken, that child may still end up in court in front of a sheriff, either as an accused person or on a reference for a Section 67 proof of facts or some other hearing-related application. I've also mentioned that the very wide range of background and experiences of newly appointed sheriffs. Some will have no experience at all of the children's referral system or custody disputes, family disputes. Some will have had very significant experience examining child witnesses in cases involving serious sexual or violent offending, and we have to provide training that is suitable for all. So I thought I would give you some examples of the training that we have provided to equip judges with the skills they need to deal with children in court, irrespective of how that child has ended up there. Now, first things first, for the purposes of the United Nations Convention on the Rights of the Child, a child is a person under the age of 18. However, in Scotland, there are a number of provisions for persons aged between 18 and 21, which give them added protection, including rules about custody and remand, and the requirement to obtain criminal justice social work input prior to sentencing, irrespective of whether or not they have been in trouble before. In addition, those up to the age of 25 benefit from the sentencing guidelines that require the rehabilitation of the offender to be the court's primary consideration in sentencing. So while the UN CRC incorporation bill remains stalled, there are a number of protections in place already. And again, I don't propose to comment on the adequacy of those protections because that's a matter of policy, but I just wanted to flag their existence to you. Now, the young person's sentencing guidelines are evidence-based, and the Sentencing Council commissioned work from, amongst others, child psychologists and experts on brain development before the guidelines were issued. But it is fair to say that they are innovative in having selected 25 as the cutoff age for a young person. And complying with the guidelines requires judges, sheriffs, High Court judges and JPs to adjust their thinking and understanding about issues of maturity, the development of the brain, and the impact of adverse childhood experiences. Now, at the JI, we already deliver skills training to judges on vulnerable witnesses, the use of special measures, how to take a child's evidence by pre-recorded commission, which is the default in the High Court in sexual assault cases. We provide training on how the brain functions, inappropriate questioning, and how to protect the dignity and privacy of witnesses. We have delivered numerous courses on these issues and have several publications which are regularly updated and reviewed in light of evolving practice and experience. And all of these are relevant to the way a child will be treated if they are involved in any kind of court process, and indeed in whatever capacity. But in anticipation of the coming into force of the young person's sentencing guidelines this January, I wrote a detailed briefing paper, effectively a paper advising judges how to use the guidelines. And I designed and delivered a bespoke training course on the subject. That course included contributions from the Lord Justice Clerk, who is Scotland's second most senior judge and the chair of the Sentencing Council, as well as a contribution from a High Court judge who sits in the Old Bailey and who was central to the implementation of sentencing guidelines in England and Wales. The course involved workshops and practical case studies where judges were given the opportunity to put their learning into practice. These sentencing guidelines are also covered in depth in the induction courses I mentioned and form part of the intensive modules on sentencing. I mentioned a moment ago that in the High Court, it is the default for evidence of child witnesses to be pre-recorded. That relates to cases involving allegations of sexual assault, which make up something like 85% of the work of the High Court. Now, that particular arrangement was introduced as a pilot and was due to be evaluated and rolled out across the Shire Court, but the rollout was unfortunately interrupted by COVID. Nevertheless, the pre-recording of a child's evidence is a routine special measure used to obtain their evidence, and sheriffs have had detailed training on how to manage such commissions. We also provide training on the use of other special measures for child witnesses, for example, the use of screens or giving evidence remotely, and our intranet, the Judicial Hub, has a whole section dedicated to resources on how you deal with remote and virtual courts. So that's crime, but what about children's contact with court in the civil context? You'll be familiar with the Children's Scotland Act 2020, which is currently partially in force, but once fully enforced, will substantially affect the court's obligations towards children. Now, I was aware that this would be a significant piece of legislation and would require a detailed training response. So we started planning as soon as the bill was published. We decided that we would have a two-pronged approach, a series of in-person courses with presentations by subject matter experts, including academics and from the Children's Commissioner, and Maria has spoken at twice, I think, at these courses. And alongside that, we would have a resource kit with briefing papers, analysis, commentary, and advice on various aspects of the Act, including how to take the views of a child. And that resource kit allows judges who were, for whatever reason, unable to attend the courses to access all the relevant materials, which they could work through at their own pace and refer back to whenever they want to refresh their learning. Now, that resource kit is dynamic and we update it in line with legislative developments. This type of blended learning response means that there is a just-in-time resource available to judges whenever they need it. Now, it's been very successful, and we have received extremely positive responses when we survey for the effectiveness of this resource. We have a similar resource kit ready to go for the United Nations Convention on the Rights of the Child Incorporation Bill, and it would have been published last summer in 2021. Obviously, the Supreme Court decision delayed that, but it will be ready to go just as soon as the final shape of the Act is known. Now, these sort of resource kits draw on our success in delivering training on the Domestic Abuse Scotland Act, which was introduced in 2018, where we delivered that training through a blended form, which includes a series of in-person courses, along with pre-course education and post-course reading. That Act, as I'm sure you know, introduced the concept of coercive control as criminal behaviour, which, along with other features, could be aggravated by having occurred in the presence of a child. Coercive and controlling behaviour can also feature in civil disputes involving children, but I was a little concerned that it might not be as well as understood as it is in the criminal context. And so to address that, I commissioned a paper looking specifically at the impact on children of experiencing a coercive relationship, how that might manifest itself, and what judges should be aware of when making decisions about contact and residence. This has raised awareness of an issue that might otherwise have been overlooked, and I hope helps support judges' decision-making in this difficult area. And that paper is also part of the resource kit and now used in the induction course as well. So I picked these two courses and resource kits really just to illustrate how comprehensive, responsive and thorough the training is that judges receive. And unless you had had a look at our annual report or strategy, you might not have been aware of that. And to be fair, there's absolutely no reason why you should have been. But you can be confident that ensuring the judiciary of Scotland is properly educated and trained is a matter that is taken very seriously and at the highest level. Now, I'm maybe got a couple of minutes left for any questions. I don't know quite how we're doing questions, whether it's through the chat, David, or people contributing.
Well, Susan, that was fantastic. Thank you very much. I think we have time for probably one question, and I'm going to. There are some on the chat, and if you're able to do so, I might ask you to perhaps respond to some of these in writing afterwards, just on the chat or the Q&A. But I wonder if I just bring two questions together. There's a question there about whether sheriffs, judges are trained, whether their training includes input from those with life experience. Children and young people with life experience have gone through the criminal justice system, and associated with that, whether in addition to training on how to deal with witnesses and vulnerable victims and witnesses, does the training also include dealing with young people who are accused of offences and how to address those? So perhaps I can ask you to address that question, and after that, because of our quite tight timetable, I think we'd have to invite you to deal with anything else in writing.
Yes, well, happy to. I'll take the first point very quickly. Life experience, absolutely. For example, in the course about the use of the sentencing guidelines, Karen McCluskey presented, and she presented drawing on material that they have of sort of life experience and the experience of young people in the criminal justice system. So absolutely, that's very much at the front of it. And in relation to the examination of young persons who are accused, in the training, we don't really differentiate between them being witnesses or accused, because the same issues arise. So the training that we provide on how you would examine a witness if they were at a commission, for example, precisely the same considerations would apply if it was an accused child. So yes, we do.
Susan, thank you very much. A truly professional broadcasting answer, right on time. I just want to thank you very much on behalf of the conference for your input this afternoon. I think that's a tremendous insight into the training that judges and sheriffs get. So thank you very much.